Charlotte, North Carolina criminal defense attorney Rob Corbett is here. Rob, what is your take on what the judge should do in terms of allowing anything concerning the hearsay of the drugs used in high school by Kouri Richins? Should the jury hear any of or all of this?
First off, thank you for having me. It makes or poses an interesting question in terms of what the judge is going to have to consider. You are allowed to bring in outside acts in a trial, but you have to say that you are bringing it in for a particular purpose. So in this case, what they're trying to do, the defense is trying to do, is bring in prior drug use of the victim to show that he had knowledge, to show that he had access, to show that he had familiarity with controlled substances. What the judge is going to do is going to be a balancing test. First, the judge has to decide, is that information relevant? And I would contend it is relevant, since the victim did apparently die or was killed by some type of, fentanyl or drug overdose. So I can see that it is relevant. But then the judge would then have to balance it out to see, in terms of, even though it's relevant, is it too remote in time? We're talking about during high school years, or where he may have had or used something and not used the particular drugs that were found in his system. So when you're doing that, I can probably see the judge saying that although it may be relevant in terms of some drug use that he may have used, but we're talking about too remote in time. If there's information or evidence that he did use drugs, controlled substances at closer point to the time and death, then I can see that being more relevant, and I can see a judge possibly letting that in. But where we are now, I think it may be too remote. It's too far of a stretch. There's not enough of a connection to allow that to come in.
There is another little nuanced piece of this puzzle, and that is that the reason the defense is claiming they should be able to bring this up, it's because the prosecutor asked him the question. I think it was before. I'm not sure you were monitoring this trial when this happened earlier this morning. The prosecution said, "Have you ever heard of Eric ever using any illicit street drugs?" And the answer to that question was no. Well, that's what started this whole thing, because the defense popped up and, after the jury was out, argued, well, look, we've got the transcript from the preliminary hearing where he said, yes, I had heard that Eric used these Red Devils while he was in high school. So they're attacking it from that angle. They want to be able to bring him back in and just clarify with what he said at the preliminary hearing, that indeed he had heard that Eric had used drugs, albeit back in high school. It's a little bit nuanced, where they're trying to impeach and use that to get it in. What's your take?
And thank you for bringing that to my attention. So you're right, that does change the calculus somewhat, because although it may not have come in for some other reason, like I was discussing earlier, that we're saying it's too remote, it's not the same type of drug that was found in a system, but now they're trying to say that I can't get it in for this particular way in terms of what I had discussed, but they're saying, well, I want to get it in for a different way. The prosecutor opened the door, meaning that the defense didn't ask that question and then tried to say, now I want to bring this in. It was the prosecutor who opened the door, so the defense can say, we didn't elicit this information. It didn't come in through us. They asked that question. He has said something that we know is untrue because he testified under oath to something else. So as a result of that, then I would probably change my analysis and say that it would come in for that limited purpose only.
All right, well, let's see. We'll set the stage. Let's see what the judge decides. We'll get a break here. More from Kouri Richins' murder